Good morning. Ms. Macbeth, are you there?
Hi, can
Mr.
you?
Stubbe?
Oh, I'm sorry. I just want to make sure you could hear me.
Yes, I can hear you.
Great, thanks.
Thank you. Mr. Stubbe?
Yeah, I'm here.
I do have. Okay, great. Your mic is working. Ms. Jayapal, can I check that your mic is working?
Good morning.
Good morning. Thank you. Mr. Benz,
Good morning.
can we check that your video is working?
Good morning again.
Good morning. Thank you. Mr. Buck? Ms. Macbeth?
Hello.
Hello.
Can,
Ms. Macbeth? Sorry, I'm not sure where that feedback is coming from. Just a second. Hi, Ms. Macbeth. Can we check if your mic is working?
Can you hear
hear me?
Yes, I can hear you. Just a second. Let me see. And can you speak again, Ms. Macbeth?
1, 2, 3, 4, 5.
Perfect. Thank you.
Okay, thank you. So I can mute again, correct?
Yes.
Okay.
Thank you.
Thanks.
And Chairman Nadler, can we check to see if your mic is working?
My mic is working.
Perfect. Thank you so much. Ms. Dimmings, can we check to see if your mic is working?
Yes, good morning. Can you hear me?
Good morning. Yes. Thank you so much.
Wonderful. Thank you.
And Mr. Buck, can we check to see if your video and mic are working?
Can you hear me now?
Yes, I can hear you. Can you see turn your video on so we can see that your video is working? Perfect. Thank you so much. And Mr. Fitzgerald, can we see if your mic and video are working?
Hello.
Good morning. Thank you so
1,
much.
2, 3, 4.
Yes, we can hear you. Thank you. And Mr. Johnson, can we see that your mic is working?
Yeah, how's that? 1, 2, 3, 4, 5.
Perfect. Thank you so much.
Thank you.
Hi, Ms. Bartz. Can we work to see if your mic is working?
Yes, but
Oh, I think you unmuted yourself.
uh, can I hear? I can't hear anyone, or we're not on yet.
Well, your mic is working. We will be starting in a few minutes.
Okay, so it's okay then. And then I try to figure out, is it okay the center, because it's like strange nowadays. Is it okay, the camera and everything?
Yes, you look great.
Okay, so it works fine. Okay, it's hard for me to say. Mic is working, so it should work, because I couldn't hear anyone, so I wasn't sure. Okay, sounds good. Thank you.
Thank you.
Good morning, Chairman. How are you? It's Daryl.
I'm okay, thank you.
I must admit, I knew things were going to change in the 2 years I was gone. I'm having done 2 years of Zooms, or a year of Zooms. I'm still not ready for for doing it this way, but hopefully it's going to be short-lived.
Hopefully.
Yeah, I just got it.
This is just a friendly reminder to keep your mics muted if you are not speaking. Thank you. Good morning, Mr. Jeffries. Can we check to see if your mic and video are working?
Hello. Hi, how are you?
Perfect. Thank you. Sorry, I lost you for a second. Mr. Owens, can we check to see if your video and mic are working? Ms. Fishbach, can we check to see if your mic is working?
Is it working?
Perfect. Thank you so much.
Thank you.
Since we haven't started yet, I just want to ask any Republicans who need to leave early and want to ask questions, just text me. I'm going to defer to the end to ask questions. So anybody that wants to be recognized, if you would let me know, I'll let the chair know and we can proceed that way.
Good morning, everyone. We will be starting soon. This is just a friendly reminder to keep your mics muted when you are not talking. Thank you.
The subcommittee will come to order, and without objection, the chair is authorized to declare recesses of the committee at any time. Good morning and welcome to today's hearing on the impact of forced arbitration on the fundamental rights of hardworking Americans and our system of laws. Before we begin, I'd like to remind the members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as a part of today's hearing. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I would also remind all members that guidance from the Office of Attending Physician states that face coverings are required for all meetings in an enclosed space, such as committee hearings. I expect all members on both sides of the aisle to wear a mask for the duration of today's hearing. I now recognize myself for an opening statement. I want to thank the esteemed witnesses for agreeing to offer testimony at this important hearing today. I'd also like to extend a sincere thanks to Chairman David Cicilline for allowing me the honor of chairing this hearing in his absence, as he is disposed as an impeachment manager now on trial in the Senate. This was to be Chairman Cicilline's first subcommittee hearing of this new Congress, and its subject happened to concern the issue of forced arbitration, which is an issue that I have championed since I first came to Congress back in 2007. So I'm particularly honored to chair this hearing in his absence. Forced arbitration is an underhanded maneuver that corporations use to trick consumers, workers, and small businesses out of their right to go to court and seek damages from a jury of their peers when they get injured or cheated. From consumer purchases to nursing home contracts for the elderly, even when you accept a job offer, corporations use small print to put arbitration clauses into the paperwork that you sign, and without ever knowing it, you have signed away your right to seek justice in court. Instead, you have been tricked into a secret, for-profit dispute resolution process known as binding arbitration. In forced arbitration, the deck is stacked against the little guy, and most often, the corporation comes out on top. Consumers, workers, and small business people shouldn't need a law degree to be able to go about their daily lives without giving up their constitutional rights. But that's exactly what's happening in our society today. Every day, when you're trying to get a job, or you want to purchase a car, or even to buy a TV online, you find yourself pitted against a multi-million-dollar corporate legal department and their 10-page small print contract that forces you to choose between foregoing a necessity or signing away your Seventh Amendment constitutional right to trial by jury. The truth is, you really don't have a choice because everywhere you go to make a purchase or seek employment, you run right into a forced arbitration clause. It's gotten to the point where it's a take it or leave it situation. You can't get a cell phone or a credit card or even a job nowadays unless you sign away your rights, because that's what every corporation requires. They force you into binding arbitration because it benefits them, and it's at your expense. It's not fair, and it's not right. And I'm also not just talking about traditional pen and paper contracts. Arbitration clauses are hidden in the terms and conditions when you download an app. They are hidden in employment paperwork when you get a new job, in packaging for all of your devices, and in software updates you don't even realize you're getting. Forced arbitration clauses have even been found enforceable when employees are forced to sign a non-negotiable contract update during their mid-year review. If you've signed an arbitration clause, you no longer have a right to take your dispute to court for a trial. Instead, you're forced into the secret, for-profit, forced arbitration setup where the corporation that puts you in the arbitration process also chooses where your case will be handled, the judge to hear your case, and the law the judge will apply. With a setup like that, it's no wonder that most of the time the corporations come out on top. And if this sounds unfair, well, it is. Big businesses that already had all the power in the relationship between itself and someone like you or me stack the deck so that they can avoid the only thing out there that could hold them accountable, the United States justice system. Accountability, or the lack thereof. That is why this arbitration issue matters, because without accountability, without access to the courthouse, the tragic stories of Americans harmed by corporations can never become a force for good. Class actions can stop banks from defrauding thousands of their customers. They can thwart corporations from having a culture of sexual abuse of women. Public court cases can close nursing homes perpetrating widespread abuse. and federal judges can ensure that laws protecting the jobs of working people are obeyed. But this balancing of the scales of justice can never happen if forced arbitration clauses continue to shield corporations from you having your day in court. I have been a proud sponsor of the Forced Arbitration and Justice Repeal Act, also known as the FAIR Act, which was filed today with 155 co-sponsors. And if it passes, it would secure the accountability that is so lacking today by banning the enforcement of forced arbitration clauses in consumer, antitrust, employment, and civil rights disputes. Corporations have proven time and again that when given the power, they'll take more. We need to lay down rules of the road to ensure that people going about their daily lives are not forced to give up their constitutional rights. And with that, I would like to welcome the new members of the subcommittee to the subcommittee. And I now recognize the distinguished gentleman from Colorado, Ranking Member Buck, for his opening statement.
Thank you, Mr. Chairman, and I want to thank you and Mr. Cicilline, Mr. Nadler for calling this important hearing. There are a number of issues that I think are really fascinating and need to be explored, and I'm really looking forward to hearing the testimony of the witnesses today. The idea that we will do away with arbitration clauses in contracts and not have a serious impact on our judicial system is something that we need to explore and probably in a separate hearing, since it doesn't appear that these witnesses are necessarily in a position to talk about the impact of that kind of change to our judicial system. There are some discrete areas, and sexual harassment is one of them that I think needs to really be explored to decide whether we take that out of arbitration clauses or not. But there are so many, literally millions of contracts that are entered into every year that contain arbitration clauses. If we did away with those, it would have a serious impact. Arbitration is a fair system. It is a system that many consumers and others have benefited from the speed that arbitration, the process, how quickly the process occurs. It also, oftentimes, the individuals that are involved, the plaintiffs in the arbitration clauses, receive awards, and they don't have to pay exorbitant attorney's fees with those awards. And so I'm particularly interested in hearing Ms. Carlson's testimony today. As a Fox News viewer and as a Fox News participant, guest sometimes, I have followed that organization somewhat closely. I am really heartened by the fact that they have dealt with a very serious problem. They have gotten rid of a number of predators, people that I would consider predators in their organization. They have tried to clean that organization up, and I think have to a certain extent really moved forward on those issues. And I'm also very proud that I am a big fan of Ms. Carlson's, and she, with her courage, really changed not just an organization, but the way a number of people in this country look at sexual harassment in the workplace. And so I'm particularly interested in hearing the testimony of these witnesses and how we can balance the needs of dealing with certain areas. I think one of the things when I read the testimony of the witnesses and some other materials last night, what struck me was the difference between doing away with arbitration clauses and doing away with the secrecy provisions in contracts. Obviously, I think all of us, or at least most of us, would agree that if there is a predator in the workplace, there should not be secrecy. That person should not be staying in the workplace. The person should be outed, and people should be warned about that kind of behavior for that employer and in other areas. But that doesn't mean that arbitration by itself is a problem. And so I think that Those are two issues that I want to make sure we distinguish in the employment context of arbitration clauses, and are able to make a good judgment about that. But I look forward to this testimony and the hearing, and I thank the gentleman from Georgia for recognizing me.
I thank you, Ranking Member Buck. And the chair now recognizes the chairman of the full committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman, for holding today's important hearing on forced arbitration. Nearly a century ago, Congress enacted the Federal Arbitration Act to allow merchants to resolve run-of-the-mill contract disputes through a system of private arbitration that would be legally enforceable. The system that Congress envisioned was to be used voluntarily and only between merchants of equal bargaining power. Thanks to a series of disastrous Supreme Court decisions, however, this system has been turned entirely on its head. Private arbitration has been transformed from a voluntary forum for companies to resolve commercial disputes into a legal nightmare for millions of consumers, employees, and others who are forced into arbitration and are unable to enforce fundamental rights in court. Many companies use forced arbitration as a tool to protect themselves from consumers and workers who seek to hold them accountable for alleged wrongdoing. By burying a forced arbitration clause deep within the fine print of take it or leave it consumer and employment contracts, companies can effectively evade the court system, where plaintiffs have far greater legal protections and hide behind a one-sided process that is tilted in their favor. For example, arbitration generally limits discovery, does not adhere to the rules of civil procedure, can prohibit class actions, may preclude the right of appeal and the proceedings, and often the results must stay secret. For millions of other small businesses, consumers, and employees, the precondition of obtaining a basic service or product, such as a bank account, a cell phone, or even a job, is that they must agree to resolve any disputes in private arbitration, whether they know it or not. That means that their ability to enforce civil rights, consumer, labor, and antitrust laws are subject to the whims of a private arbitrator who is not required to provide plaintiffs with any of the fundamental protections guaranteed in the courts. We have a bedrock principle in this country, and that is that all Americans deserve their day in court. We make a mockery of this principle, however, when we allow individuals to be stripped of this right and to be forced into private arbitration proceedings without the safeguards that our judicial system affords. Yet that is where we find ourselves today. This problem began in earnest in the 1980s with a series of Supreme Court decisions that misapplied the clear legislative intent of Congress and dramatically expanded the ability of companies to limit the rights of consumers and workers through forced arbitration. In 1984, the court granted corporations the right to enforce arbitration clauses even when state law rendered them null and void. And strikingly, in 1985, the court allowed arbitration proceedings to be used not just to settle contracts, but also to interpret laws enacted by Congress that implicate fundamental rights. Most recently, a conservative majority on the Supreme Court reached new heights in misreading what Congress intended. In a 5-4 decision in the Epic Systems case, the court held that employers can combine forced arbitration clauses with class action bans to prevent workers from banding together to hold law-breaking employers accountable, despite clear authority for workers to bring their claims under the National Labor Relations Act. That is why shortly I will be reintroducing the Restoring Justice for Workers Act, legislation that would end forced arbitration in employment contracts and would protect workers' rights to pursue work-related claims in court. As Justice Ruth Bader Ginsburg stated in her dissent in Epic Systems, a congressional correction is urgently in order. I strongly agree. I also strongly support the Forced Arbitration and Justice Repeal Act, or FAIR Act, introduced by the gentleman from Georgia, Mr. Johnson, which would prohibit forced arbitration in consumer, employment, civil rights, and antitrust disputes. This legislation passed with overwhelming support last Congress by a bipartisan vote of 225 to 186. I applaud Congressman Johnson for his leadership on this legislation, and I look forward to passage of this legislation again this Congress. The widespread use of forced arbitration is a serious threat to our entire legal system and to the basic tenets of our democracy. For many companies, arbitration has become a get-out-of-jail-free card to circumvent the basic rights of consumers and workers. It is up to Congress to reverse this dangerous trend, and I look forward to hearing from our distinguished panel of witnesses about how best to address this important issue. I thank the chairman for holding today's hearing, and I yield back the balance of my time.
I thank the gentleman from New York, and with that, it is now my pleasure to introduce today's witnesses. Our first witness is Professor Miriam Gillis, who has been the Paul R. Verkel Chair in Public Law at the Benjamin N. Cardozo School of Law since 2003. Before being appointed the Paul Verkel Chair, Ms. Gillis served as an associate professor and lecturer of law at the Benjamin N. Cardozo School. Additionally, Ms. Giles sits on the boards of both the Justice Resource Center and Public Justice, where she is an executive committee member of the Class Action Preservation Project. She received her Bachelor of Arts at Harvard College and her law degree at Yale Law School. Welcome, Ms. Gillis. Our second witness is Gretchen Carlson, an acclaimed journalist, best-selling author, filmmaker, and advocate. Ms. Carlson hosted The Real Story and co-hosted Fox and Friends for more than 7 years on Fox News. In 2016, Ms. Carlson was forced out of Fox after her workplace harassment complaint became public, and has since focused her energy on advocating for important legislative changes to protect sexual assault and sexual harassment survivors. She has written 2 New York Times bestsellers and has been recognized by the New York Women in Communications, the National Organization for Women, and the YWCA of Greater Los Angeles for her advocacy work. Ms. Carlson is the former first Miss America to serve as chair of the organization. She received her Bachelor of Arts at Stanford University and serves as a national trustee for the March of Dimes. Welcome back, Ms. Carlson. Today's third witness is Jacob Wise, the founder and president of OJ Commerce. Mr. Wise has a long career as a successful business owner and entrepreneur. In 1998, he founded BabyAge.com, a premier online pregnancy and juvenile product marketplace that has often been featured on Internet Retailer as one of the top 500 internet companies. Most recently, Mr. Weiss founded OJ Commerce, a successful online retailer focused on selling home and office goods. OJ Commerce does a great deal of their business on other platforms, especially Amazon.com. When Mr. Wise had a dispute with Amazon regarding their unfair market practices, he learned that buried in the small print of his contract was a forced arbitration clause. Mr. Wise has spent years attempting to reach a settlement with Amazon through arbitration. Welcome, Mr. Wise. And our last witness at today's hearing is G. Roger King, the Senior Labor and Employment Counsel at the HR Policy Association. He recently retired from the Jones Day Law Firm, where he was a partner. Previously, Mr. King served as a professional staff counsel with the United States Senate Labor Committee. Mr. King has extensive experience with labor, employment, healthcare, contract administration, and collective bargaining law. He has represented dozens of clients over the course of his career, including the United States Chamber of Commerce, the National Manufacturers Association, Verizon, General Motors, and ProMedica. Mr. King received his undergraduate degree from Miami University and his JD from Cornell University Law School. Welcome, Mr. King. We welcome all of our distinguished witnesses and we thank them for their participation. And I want to remind our witnesses that they have an obligation to provide truthful testimony today and that making a false statement to Congress is potentially punishable under Section 1001 of Title 18 of the United States Code. I'll note at this time that I have opening statements from Chairman of the Subcommittee, David Cicilline, along with member of the Subcommittee, Congressman Joe Neguse, who, along with David Cicilline, are impeachment managers, or is an impeachment manager, and they are on trial before the Senate right now. I have their statements for entry into the record without objection. Hearing none, the documents are admitted. Please note, witnesses, that your written statements will be entered into the record in their entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time frame, there is a timing light in WebEx. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns to red, it signals that your 5 minutes have expired. I would also note that Mr. Weiss's counsel is participating in the WebEx platform today pursuant to Section G of the House Rules Committee's Remote Committee Proceedings Regulations. I now recognize Professor Gillis for 5 minutes.
Chairman Nadler, Chairman Johnson, Ranking Member Buck, distinguished members of the subcommittee, thank you for inviting me back to address this important issue. It is a privilege to come before you, and in my few minutes, I'd like to briefly explain how forced arbitration clauses strip us of our legal rights. Forced arbitration clauses are, as many of the opening statements have already described, these are provisions buried in the fine print of take it or leave it contracts that require all disputes to be resolved in private one-on-one arbitrations. But what this really means is that if a company rips off its customers or employees, those customers or employees are essentially powerless to do anything about it. They can't go to court. They can't band together to bring a class action. They can't even proceed as a group in arbitration. The only thing an individual can do is take on all the costs and time of going against the company one-on-one, which, let's be honest, most rational people simply won't do. And the data shows this quite clearly. For example, one study estimated that 98% of workers who suffer harms in the workplace abandon their claims rather than file individual arbitrations. What this reveals, I think, is that forced arbitration clauses do not encourage workers to bring claims, but only serve to squelch those claims. As such, these provisions have allowed companies to immunize themselves from all forms of legal accountability by simply adding some magic words to their contracts, their standard form contracts, click wrap agreements, envelope stuffers, all methods of conveyance designed to obscure or minimize the immensity of the rights that are being forfeited. And not surprisingly, study after study has also shown that workers, veterans, consumers, small business owners often have no idea that they've entered into contracts that deprive them of the right to go to court before a jury of their peers. Given this reality, it won't surprise you that over the past decade, class banning, forced arbitration clauses have become so commonplace that it's impossible to find a product, a service, an amenity of modern life that doesn't require us to first sign away our rights. Rights under consumer, employment, civil rights, antitrust statutes, rights that this Congress and your state counterparts enacted to protect American citizens. Now, to give you a sense of just how enthusiastically companies have embraced forced arbitration, in employment, over 60 million American workers are currently subject to forced arbitration. That's more than half the non-unionized workforce. And economists predict that by 2024, 80% of workers will be bound to these provisions. I just want to stop there for a moment to really think about this. 80% of all workers will not have the right to resolve claims for sexual harassment, racial discrimination, wage theft, wrongful termination. 80% of employers simply declining to be bound by federal and state workplace protection laws. Worse yet, and I think this is also important, the costs of forced arbitration are disproportionately borne by low-wage workers and those working in critical frontline jobs such as education and healthcare that are largely comprised of women and African Americans. In consumer transactions, probably every single person on this call in this country is subject to a forced arbitration clause in some aspect of their consumer lives. To use a credit card, open a checking account, get a loan, join a gym, send your kid to camp, put your mom in a nursing home, you have to first sign away your rights to seek legal redress for violations of privacy, product liability, data breaches, fraud, illegal trading activity, and more. And despite what the Chamber of Commerce or Mr. King, the next witness, may tell you, forcing arbitration on an unknowing public is not about achieving fair, expeditious, or cost-effective resolutions. It's about suppressing legal claims altogether. But you don't have to take my word for it. You can just look at the actions of companies like Chipotle, Uber, and DoorDash. These companies impose class-banning forced arbitration clauses on their workers. But when thousands of workers actually tried to bring single-file individual arbitrations, these companies balked at the time and expense of honoring their own contracts. And then they tried to do everything they could to escape arbitration, including going to court to argue that worker claims should actually be brought as a class action. This is the very thing, of course, that their contracts prohibit. The hypocrisy here is incredible. But
Ms.
what it
Gillis,
reveals...
if you would wrap up, you're beyond your 5 minutes.
Oh, I'm so sorry. I'll just wrap up by saying that it's abundantly clear the federal legislation is needed to halt this worsening situation, and I'm happy to answer any questions I can. Thank you so much for your time.
Thank you. And welcome back to the committee, Ms. Gillis. Next, we will hear from Ms. Carlson. Ms. Carlson, you may begin. You're recognized for 5 minutes.
Chairman Cicilline, Chairman Johnson, Ranking Member Buck, other distinguished members of the committee, thank you so much for providing me the opportunity to be back in front of this committee to testify about my experience with forced arbitration. 4.5 years ago, on July 6th, 2016, I jumped off the cliff all by myself, and I sued my boss, former Fox News chairman and CEO, Roger Ailes, for sexual harassment. It was the biggest decision of my life. Once public, the story ran like wildfire all around the world. Back then, I could have never imagined my story would help ignite the Me Too movement and that I would become one of the prominent faces fighting against forced arbitration in the workplace. But here's what I found out. Courage is contagious, and the cultural revolution we're still experiencing is long overdue. The first step for me was telling the truth. The next step was to passionately work to change the system for all women and men across our country. So I've spent much of the last 4 years walking the halls of Congress, encouraging legislators to take real, meaningful action to help workplace harassment victims, to take the issue out of the shadows of secrecy. In December 2017, I proudly joined legislators from both parties, Congresswomen Bustos and Stefanik, and Senators Gillibrand and Graham, to introduce the Ending Forced Arbitration of Sexual Harassment Act. In February 2019, the bill was reintroduced in the House. And here we are again with the new Congress, and here I am again talking about my bill and forced arbitration, because quite honestly, I truly believe that this legislation will change the landscape of the American workplace, retaining women and people of color, while at the same time making it safer for everyone. So why is this bill so important to me? Because it's actually not about me. This is about the thousands of women who reached out to me after their story became public, making me realize that almost every woman in our country has a story, and that's shameful. So many of these women have shared their emotional stories of pain, but mostly about how they were silenced, because that's what forced arbitration does. And it turns out that silencing is the harasser's best friend. because it perpetuates the systemic problem of protecting predators and pushing women out of the workforce. And sadly, my story is not unique. Sexual harassment in the workforce, not a new problem. Neither is the use of forced arbitration to deal with it, to cover up the dirty laundry. You have Dob Charney, the founder and former CEO of American Apparel, sexually harassing people for years, but nobody ever knew about it because of secret arbitration. Another horrifying example, the more than 180 women who reported sexually being assaulted by massage therapists when they simply went to get a massage at Massage Envy spas. These women put trust in the company and the employees only to suffer the trauma of being forced back into secrecy. And one case in particular that really resonated with me was Lily Siebert from California, because she says she was sexually assaulted by her therapist. And then when she went to cancel her membership with Massage Envy, simply going to do that in the app, she agreed to forced arbitration. That doesn't seem to be fair. There's the story of Danny Masterson, the actor and well-known Scientologist who allegedly raped several women, but because there's a forced arbitration clause in the Scientology contracts, one the women say they were coerced into signing, these cases will probably never see the public eye. It's impossible to know exactly how many women have faced this kind of situation, but you just heard from the other witness, 60 million Americans have these clauses in their employment contracts, and by 2024, 80% of the private sector non-union workers will be forced into arbitration. That's why I aim to change this. My going public opened the floodgates to shed light on a pervasive epidemic. Weinstein, Cosby, O'Reilly, Moonves, Matt Lauer, Charlie Rose, Mark Halperin, so many more. Since my movement started, I've helped states to pass these eradicating arbitration laws as well. But here's what's happening when those laws go to be tested at the state level. The judges feel compelled to honor the federal law. And so they're still putting these cases back into arbitration. I want to leave you with this and have you understand just for a moment what it feels like to have the courage to come forward, because this could be your wife, your daughter, or your granddaughter. A woman finally decides to go to HR to complain. If she has an arbitration clause, the reaction will be, phew, good. No one will ever know about this. Her case is promptly thrown into the secret chamber. The woman will likely be blacklisted, demoted, and fired from her job. In arbitration, she gets no appeals. And so the cycle continues. It's a repeat business thing. We've lost millions of women in the workforce due to this, and just in the last year due to COVID.
Ms. Carlson, if you could wrap up, please.
Thank you to the brave members of Congress from both sides for drawing a line in the sand, because this is not partisan. This is apolitical. And it's my great hope that we can get something done that's bipartisan to help women in this country. Thank you.
Thank you, Ms. Carlson. We have seen and heard you walk in the halls of Congress for years, and I thank you for your diligence. And with that, I would like to now recognize Mr. Weiss, who's recognized for 5 minutes. Mr. Weiss, unmute yourself.
Sorry. Good morning, Chairman Johnson, Ranking Member Buck, and Subcommittee members. My name is Jacob Weiss. I've been a business owner in e-commerce for the last 20 years. In 2010, I started OJ Commerce, a business that sells home goods through online marketplaces and our own website. We sell thousands of brands and over 500,000 items. A significant part of our business is done through Amazon's marketplace. I'm here today to share my experience trying to hold Amazon accountable for the harm it's caused my business. OJ Commerce has a team of hardworking employees who have grown OJ Commerce into a successful business. But Amazon's forced arbitration clauses have made it impossible to get a fair shake. The system is rigged against small and mid-sized business owners. Amazon controls so much of the online retail market that it's impossible for an e-commerce company to succeed without selling on its website. But before Amazon would let me sell on its site, it forced me to sign an agreement. I couldn't negotiate the terms of that agreement, and I couldn't sell on Amazon without signing that agreement. And since no e-commerce company can survive without Amazon, I had no choice but to sign that agreement. Amazon's agreement forbids lawsuits and forces arbitration to resolve disputes. The agreement also forbids class actions, which means businesses can't share the cost of arbitrating against Amazon. This class action waiver alone has insulated Amazon from even having to face justice, because justice is cost prohibitive. It simply makes no sense to risk tens of thousands of dollars in arbitration, legal, and expert fees to recover a few $1,000s. But as a business owner, those few $1,000s can mean the difference of making payroll. Forced arbitration puts businesses like OJ Commerce at a severe disadvantage. Number one, the filing fees are thousands of dollars. Number two, you have to pay arbitrators hundreds of dollars an hour to hear your case. Number three, arbitration severely limits the scope of discovery, which makes obtaining the evidence you need to prove your case nearly impossible. Number four, Amazon has mastered the art of driving up the cost of arbitration through motions, objections, and hearings. So while proponents of arbitration tout its speedy and efficiency, my experience shows the process is slow, expensive, and financially infeasible for many claims. Five, arbitration rulings are not published, which means we cannot see what Amazon has done to other businesses or how those businesses have fared in arbitration. We're left in the dark, but Amazon has all the information. Finally, parties can strike potential arbitrators and rank others, which means arbitrators have a financial incentive to rule in Amazon's favor so as to keep the more likely repeat arbitration player happy and be selected again. For Amazon, this creates the perfect storm. Companies give up before they even start because they do not have the budget for this expensive process. The proof is in the excellent report the subcommittee created on digital markets. Despite millions of businesses on Amazon's website, despite internet message boards teeming with thousands of complaints against Amazon, over a 5-year period, only 163 arbitrations against Amazon. That statistic is mind-blowing. I've seen this firsthand through two forced arbitrations against Amazon. The first arose when Amazon overcharged OJ Commerce for shipping costs. Amazon fixed the problem when we notified them of the error, but refused to refund the overcharged amounts. Left with no choice, we initiated forced arbitration. Amazon took us all the way through a very expensive arbitration proceeding where OJ Commerce eventually prevailed on some of its claims, but the process cost us over $50,000 in just arbitration fees, not even attorney's fees. OJ Commerce had to pay those fees just to have its day in arbitration court. And after all those fees, I have recovered very little of what I have lost. Second arbitration against Amazon is ongoing, so I cannot go into details, but I can tell you it's been 9 months so far. So much for quick and efficient resolutions. Small businesses are the lifeblood of the American economy. Historically, companies like OJ Commerce use the antitrust laws and court system to stop marketplace bullies like Amazon. Forced arbitration and
Mr.
class
Weiss,
action
if you
waivers.
would wrap up, please, you're beyond your 5 minutes.
Yes, Mr. Chairman. Forced arbitration and class action waivers have replaced that with a system that allows Amazon to avoid facing justice. I urge you to pass the Forced Arbitration and Justice Repeal Act. It will restore balance to the marketplace and stop an abusive and unworkable systems. Businesses are not looking for handouts. We're just looking for a fair system. Thank you.
Thank you, Mr. Weiss. And now I recognize Attorney King for 5 minutes.
Thank you, Mr. Chairman. Mr. Nadler, thank you also for joining us this morning. Ranking Member Buck and distinguished members of the subcommittee. Thank you for also accepting my written testimony, and I would ask the appendices to the testimony also be made part of the record. Mr. Chairman, I'm the only practitioner testifying today. I've spent 50 years, if you will, involved in arbitration. I have drafted arbitration agreements. I have appeared in arbitration hearings. I have followed the policy developments regarding arbitration, and I believe I have a perspective that would be helpful for the subcommittee. First, I'd like to level set the discussion. Proponents of arbitration are not here to condone any type of sexual harassment, hostility in the workplace, or the like. Ms. Carlson, you have our support. We do not condone those activities. And I would note, I don't believe you ever went through the arbitration process. You were able to get your story out without any impediment, and indeed, it made news and news that was followed. And we can see that. That's not the discussion. Arbitration has many, many positive attributes. It is quicker, notwithstanding what you may hear otherwise. It's unrefuted. That is much more expeditious than going to court. It is less expensive. Mr. Weiss, I don't know your case, but I would suggest to you, if you took your issues to court, you would be paying much more than you have paid today, much, much more. And you'd still be in court, and you'd still be waiting probably for that first even discovery proceeding. But with respect to the direction of this testimony and this hearing, I submit to you we have it backwards. Every suggestion I'm hearing, and we've heard from proponents to do away with arbitration, is to put everybody in the court system. I would call this the Forced Litigation Act, if you will, pushing everybody, even those that can't afford it, into somehow a judicial, contentious relationship in a court. And there I would submit to you, employers are going to even have more advantages. And it's going to cost even more for the consumer, the employee. But let's break this down. Mr. Buck, you noted this in your opening remarks. Our court systems today are overrun, totally overrun. If any member of this committee would spend at least a week in a courthouse in their district or in their state, they would readily see the problems faced with our judicial system. The solution is not to push everybody into the courts. The courts can't handle it. The courts are not equipped to do it. So the intelligent, thoughtful approach I would suggest here is to look to the positive attributes of arbitration, which are many. Now, in the professor's testimony and other remarks today, I note the criticism of the United States Supreme Court. Well, let's step back here just for a moment. We have decision after decision by various members of the court from various ideological approaches. These are not all 5-4 cases. Virtually every member of the United States Supreme Court has supported, at one time or another, arbitration. And there's good reason for that, because the system works. As I noted in my testimony, Justice Breyer has stated the many positive attributes of arbitration. So let's not mislead people. There is consensus, even though even the harshest critics of arbitration would push back, that there are positive attributes of arbitration. That's a given. Second, let's also concede that courts are not equipped to handle whatever the multi-million-dollar figures that were suggested. We cannot have a flood of people simply going into the courts. That won't work. But furthermore, most litigants, most individuals find the court system is not friendly. Next, I'd like to really rebut the continuing misinformation that there is secrecy attached to all arbitration proceedings. That's not correct. The discussion regarding non-disclosure agreements and confidentiality agreements, as Mr. Buck stated, is a totally different discussion. Those types of clauses are not in every arbitration agreement, nor should they be. Furthermore, the thoughtful way to go is the way the American Arbitration Association is going, that permits anyone involved in arbitration to disclose the issues that were discussed and the resolution is same. Indeed, in California, arbitration decisions are reported by state law. So there is not the equation of secrecy and arbitration. That is just flat wrong. And we can talk about NDAs and confidentiality perhaps in another hearing. Furthermore, it is incorrect to suggest that there is no legal redress. It is wrong to suggest that the Equal Employment Opportunity Commission, the National Labor Relations Board, et cetera, does not have a role in vindicating employee rights. You cannot foreclose individuals in arbitration from going to those federal agencies and state agencies and many more. It is a violation of law to do so.
Mr.
So
King,
there
if you
is
could
no,
wrap up, you're beyond your
Sir.
5 minutes.
Yes, thank you, Mr. Chairman. There is absolutely no way to prohibit that. It's against the law. And finally, claimants do better in arbitration than they do in the courts. That is established. So I'd be happy to carry on this dialogue, Mr. Chairman, as we proceed with this hearing. Thank you.
Thank you, Mr. King. It's now my pleasure to recognize the chairman from the full committee, Mr. Nadler, for questions, 5 minutes. You recognize Mr. Nadler. And you may want to unmute.
Okay, am I unmuted now?
You are.
Can you hear me? Okay, thank you. Thank you, Mr. Chairman. Professor Gillies, forced arbitration has proliferated in the workplace. According to the Economic Policy Institute, more than half of working Americans are subject to forced arbitration, up from just 7.6% of workers in 1995. As a result, workers are often funneled into an arbitration trap that is expensive, time-consuming, and secretive. How does forced arbitration favor employers over workers?
Thank you, Chairman Nadler, for the question. I think that there are a number of ways in which employers are advantaged. For example, they pick the arbitral provider. Many of you are lawyers. If you could pick the judge and the jury without meaningful input from your adversary, that's a huge advantage. So right off the bat, the system is not to the advantage of employees and to the advantage of repeat player employers. They also write the rules. So while Mr. King, I think, sadly sort of described this as misinformation, the truth is that employment arbitration, each arbitration is itself secret, right? You're not supposed to talk about the arbitration. That's why Mr. Weiss is not talking about the ongoing arbitration with Amazon. And that means that employees do not know when they have claims that are common with other employees. They don't know about the practices that might be firm-wide, employer-wide. And that's something that we don't see in the court system. I mean, there are lots of other aspects of arbitration that don't benefit employees. I think you talked about them, Chairman Nadler, in your opening statement. No discovery, no rules of evidence, no right of appeal, no class actions or collective actions, hugely expensive. There are tons of problems, and that's why we see so few employees actually go into arbitration.
Thank you. Now, forced arbitration is even more common in low-wage workplaces and in industries that include a disproportionate number of women and minority workers. This has dramatically eroded the ability of these workers to collectively hold their employers accountable for systemic workplace violations such as widespread harassment and discrimination. How does forced arbitration suppress the ability of workers to file claims?
Well, I think you just sort of said it. The truth is that for low-wage workers, especially low-wage workers who are in frontline critical industries, healthcare, education, workers we really need, these workers already face tons of disadvantages in accessing justice. But forced arbitration puts a barrier between them and the courthouse that is often impenetrable. They can't get lawyers to represent them because their claims are often not of significant enough value. They can't bring class arbitrations because the employers have barred those in the contractual provisions. And it can be very hard to try to prove claims that are by their nature systemic, right? How do you prove workplace harassment? That's a claim where you need evidence about the entire workplace. And so for an individual employee, that's a tough row to hoe.
And how would you say that forced arbitration undermines the rights of women and minority workers as it relates to access to counsel?
Right. Well, first off, I just want to, step back and say that, women and minorities and low-wage workers, these vulnerable groups already have massive underrepresentation problems. I think even in the courthouse, getting to the courthouse, it can be very hard to find a lawyer. And so we have to deal with the justice gap, even once we get rid of forced arbitration, knock on wood. But it is true that in arbitration, these issues are compounded because, again, the employer is controlling the arbitral forum and often picking the arbitrator. They have a lot more access to information about the arbitrator and about the arbitral provider. So they're going to pick providers and arbitrators that benefit them. And that's really hard for an employee who knows very little about an arbitral regime to try to go up against.
The gentleman's time has expired. And at this time, I will recognize the gentleman, the ranking member, Mr. Buck, for 5 minutes.
Mr. Chairman, with your permission, I'd ask that you move down the line to other Republicans, and I'll ask questions last, if that's okay.
That will be fine. I'm doing the same thing, ranking member Buck. So at this time, we shall recognize the gentleman from California, Mr. Issa, for 5 minutes.
Thank you, Mr. Chairman. The question I have for Mr. King, or a series of them, is there any prohibition on states limiting secrecy and/or limiting what can be in other words, contract law regulated by the state? Are there any limitations on the states? Do some states already have provisions? And I'll just give the example of California, where a race or sex discrimination, notwithstanding binding arbitration, you still have a state remedy.
Yeah, you're absolutely correct, Congressman. Not only California, but other states have outlawed or prohibited non-disclosure agreements. This is not a discussion about secrecy or confidentiality. We should be talking about arbitration and its attributes or criticisms if people have them. It's a total misnomer. It's a red herring.
Now, this committee and the Oversight Committee have done extensive hearings over the years about the various major league football, baseball, and so on. Don't they all, on a mutual basis, choose binding arbitration? Isn't that a choice of the very powerful players union and the, if you will, the billionaires and millionaires?
Well, absolutely. I mean, arbitration is so well accepted at so many different levels in our society, and it's the only way to proceed. Our court systems are not equipped to handle the millions of claims that are being suggested to be thrown into them.
So let me see if we can get some consensus here in 5 minutes. It seems like all of the witnesses, yourself included, have serious concerns about forced secrecy in binding arbitration. And if we were to break out the FAIR Act, we were to break out, if you will, a little bit of what everyone's talking about. If we bifurcated the, if you will, all of the these, we'll call them forced arbitration, into damages and restitution versus secrecy, and required that any secrecy be a separate consideration, voluntarily entered into, and not part of, if you will, the first decision, the arbitrator, would that improve the current law as to sex and race discrimination, but as to a myriad of other violations?
Yeah, absolutely. That's a much more thoughtful way to proceed. I mean, we can talk separately about confidentiality and secrecy and talk about how that should or should not be handled, and talk about then how damages are pursued. We've not mentioned yet in this hearing, Congressman, ADRs, alternative dispute resolution procedures. That's what I would really suggest this committee look at. There are so many ways that consumers, employees, and others can benefit by not being in the courts and getting a resolution. And that's where the direction ought to be headed.
Can I also maybe get a second, I'm hoping everyone agrees on this part, can we also agree that
if there are a series of arbitrations and they're concluded and there's no secrecy, that there's no prohibition on either federal or state laws being passed that would allow separate class action for a pattern of behavior. Would that be correct? In other words, rather than the individual who gets his arbitrated, the group could still be allowed to form, but form based on, if you will, the disclosure of a series of wrongdoings in which, whether you win or lose in arbitration, you'd be able to make that case specifically that it was a constant pattern. In other words, we could pass a separate law for that kind of bad actor.
No, you certainly could, and I would welcome, I think others on this side of discussion would welcome a very thorough and thoughtful discussion about class actions. There are a lot of misuses and abuses. We'd like to discuss that, and there may be some ways to go forward on a bipartisan basis here. But let's not suggest that class actions are good for consumers. The data goes on and on and on. They go on forever. They're very expensive. And at the end of the day, you get that little notice in the mail that you're going to get $5.50 or something, and most people just disregard it. That is such a racket, if you will, Congressman, that's been portrayed as a savior for the American consumer. Not true.
Yeah, and I've been the victim of class action, SEC abuse, if you will, in the past. So I'm aware that there are a lot of attorneys that make all of the money in those cases. As my time is expiring, on the first
The gentleman's
point,
time
the
has
secrecy,
expired.
is there anyone that would say anything different from the other witnesses as to the questioning related to secrecy?
The gentleman's time has expired. I now recognize who? The gentleman from New York, Congressman Jones, for 5 minutes.
Thank you, Mr. Chairman. Professor Gillis, thank you for your illuminating and frankly shocking testimony. Before I ran for Congress, I was a lawyer for Westchester County, in which capacity I was a legal advisor to the Westchester County Human Rights Commission, which I hope Mr. King would consider to be a practitioner. In that capacity, I saw how the ability of Westchester County residents to have their fundamental rights vindicated was hampered by these forced arbitration agreements. My experience as a practitioner and as a former law clerk in the Southern District of New York causes me to be shocked for that reason by his inaccurate statement that these forced arbitration clauses do not prevent people from getting their rights vindicated by the EEOC or, in my case, by the Westchester County Human Rights Commission. In any event, I want to make sure my colleagues and the American people appreciate how this situation became so bad in the first place, and that is the far-right majority on the United States Supreme Court. Professor Gillis, hasn't the Roberts Court consistently supported forced arbitration in a series of predominantly 5-4 decisions along ideological lines?
Oh, that's an easy one. Thank you for the softball. Yes, of course. I mean, I don't actually even understand what Mr. King is saying here. Since 2011, when the Supreme Court decided AT&T versus Concepcion, the court has decided, by my count, about 17 decisions enforcing arbitration clauses, and the vast majority of those cases have been 5-4. With the conservatives in the majority. And the dissents are growing ever more desperate for Congress to act, because at some point it becomes difficult for lower court judges to do anything other than follow the Supreme Court's law, even if they disagree. And many courts have expressed that they disagree. So this is a real crisis in American law. And it's a crisis brought on by what many scholars think is a misinterpretation of the Federal Arbitration Act.
And thanks to that far-right majority, can corporations use arbitration to get away with discriminating against seniors, for example, violating the Age Discrimination and Employment Act?
Sorry about that. Yes, they can. In fact, corporations can violate all the statutes that Congress enacts and the state legislatures enact, and we might not ever know about it because, again, despite what Mr. King has said, these cases are shunted into hermetically sealed private arbitrations. Those arbitrations are not made public. There's no recording of those arbitrations. There's no court reporter. There's no precedent from an arbitration decision. And so violations of law are happening and they're going undetected. And so I think this is, again, I'll just keep saying, a real crisis in American law at this moment.
Thank you. This Congress, my colleagues and I on the Democratic side are fighting to pass the Equality Act, which is sponsored by Subcommittee Chairman Cicilline. The Equality Act is personal to me. One of the things it would do is hold corporations accountable for discriminating against LGBTQ plus people like me in housing, credit, and other areas of public life. Thanks to the Roberts Court, could corporations exploit forced arbitration to keep discriminating against LGBTQ plus folks with impunity?
Thank you for the question. I think this is really worrisome because as you and your colleagues seek to enact protections, and I applaud you for doing so, those protections, those laws mean nothing if they can't actually be enforced. And the way that most law in this country is enforced is through private rights of action that you include in these statutes that allow people who've been harmed by violations of those statutes to bring claims. When we instead require, or when corporations instead require that these people bring claims in arbitration, most will not do so. And those violations are never heard about. While it's true we have public agencies who can engage in enforcement actions and investigations, you know as well as I do, it's impossible for agencies to monitor every transaction.
Professor Gillis, I just want to ask you one final question. Now that we have a 6-3 far-right majority,
time has expired.
Thank you.
Sorry about that.
It's all right.
I shall now recognize the gentleman from Louisiana, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman. You know, I just have to say at the outset here, you know, your opening statement this morning seemed to portray all American companies somehow as the bad guy, and that, you know, they have sinister motives aimed at scamming consumers and eviscerating their constitutional rights. And sometimes it feels like that narrative and that broad brush have really gotten old and tired. You know, then we were just told a few moments ago that there's a far right Supreme Court that's creating a crisis in American law and somehow abusing the Arbitration Act. And this is the first time, by the way, I've heard Chief Justice Roberts referred to as a far right jurist in quite some time. Look, arbitration is a key part of the American judicial system. It's advantageous to litigants on all sides, and we would abandon it at our peril. I was a practitioner for 20 years before I got to Congress. I engaged in a lot of arbitration, both on behalf of plaintiffs and defendants, and it worked really well. That's been my experience. As Mr. King pointed out this morning, he summarized, arbitration is quicker, less expensive. It keeps our court system from being overwhelmed with vexatious litigation that doesn't behoove anybody. And frankly, it's a system that works pretty well. Now, could there be some improvements in it? Yeah, of course. For example, in the area of sexual harassment claims, such as the tragic ordeal that Gretchen Carlson experienced and summarized a little bit this morning, we can reform those things. And hopefully we can bypass the partisanship and reach some consensus on those points. Let me ask just a few questions of Mr. King. Mr. King, I think your testimony's been mischaracterized here the last couple of moments, but can you just summarize briefly for folks who may be following this at home, what are just some of the pros and cons of the typical arbitration as opposed to the typical lawsuit? You mentioned cost and efficiency, but could you articulate that a little bit more?
Certainly, Congressman, you're going to get to a hearing much quicker in arbitration than you will in our courts. The court systems are bogged down in discovery and all types of motion practice, so much more expeditious for sure. As far as cost, I don't know where this information is coming from, but there are very low filing fees, if any, in arbitration. The AAA, American Arbitration Association, has led the way. So it's much easier to get into the system of justice than it is in the courts. Furthermore, to suggest that everybody's going to get a jury trial or have a lengthy trial is really misleading the American public. Very few cases go to trial. Very few cases even go to verdict in any way, shape, or form if it comes from a judge. So you're going to get a decision from an arbitrator much quicker, and I would submit just as fair, if not fair. And it's wrong to suggest that the employer picks the arbitrator. You've been involved in arbitration, I have too. It's someone in the middle. You go back and forth to pick a neutral. I wish I had the opportunity just to pick who I wanted. Not true, absolutely not true. And also in arbitration, the claimants do better. The facts are the facts. On whole, they do better than class action or in litigation. So I don't know what the pushback is here, other than perhaps the direction to push people into class action litigation. And that is not an efficient way to do business.
And in fact, in my experience, as you pointed out, arbitrators who are fair and judicious earn that reputation. And the American Arbitration Association, I think, is the group where that they are members of. And when the litigants or the parties go to choose their arbitrators, it was my experience that we always tended to go to those who had a great reputation for being fair to both sides. And so they get more work, they get to be arbitrators on more cases, and that helps overall the system. It's almost kind of like a free market analysis that people get to make when they choose those. I'm situated right now as we speak, just a few miles away from a very active state district court that I used to practice in on occasion. And I looked at the stats for 2019. They literally had less than 5 jury trials in that entire civil district court over the period of that year. Almost everything's decided by a judge. And so I think there's just a lot of misinformation. Real quick, I think I've got a couple seconds left, but some plaintiffs' attorneys, even those that are paid on contingent fee structure, won't bring cases that seek low value damage amounts. Does arbitration help claimants in that kind of situation?
No, absolutely not. And the so-called arbitration reform movement that the professor talks about harms low-income workers particularly because they don't have the wherewithal, they don't have the money to get into court. They have relatively low claims, they can't attract counsel, and if they don't have an ADR, if they don't have some type of arbitration provision to take part in, they're left out in the cold. This whole discussion is turned around. We're backwards. We're pushing people into a system that's overcrowded, not working, and not available. What we
If
need
the
to
gentleman
do
would
is
wrap
put
up,
them in a system
5
that
minutes
works.
is over.
Thank you, Mr. Chairman. Thank you, Mr. King. I'll yield back.
Thank you. I will now recognize the gentleman from Florida, Mr. Deutsch, for 5 minutes.
Thank you. Thanks, Mr. Chairman. Mr. Chairman, I want to point out what we just heard one of our colleagues talk about arguments being old and tired. I would actually like to talk about the old and the tired, real people. Because in September of 2017, Hurricane Irma cut off power across South Florida, and the outage turned the Hollywood Hills nursing home in Broward County into a death trap. Without air conditioning, the temperature climbed, and in the end, 12 residents died, dozens were injured in the sweltering heat. Surviving family members, Mr. Chairman, went to court to seek justice for their vulnerable loved ones who they thought would be safe. Plaintiffs in one suit alleged that it took 3 days before anyone called 911. But the nursing home tried to keep the case out of court using a pre-dispute arbitration clause. The families of those whose hearts gave out in that oppressive heat never got a day in court. They also didn't choose to have this wonderful arbitration govern. It was forced upon them. And the overly broad and unfair arbitration clause that was forced upon the residents and their families prevented them from exercising their right to have their claims heard by a judge. So Professor Gillis, if you could speak very specifically in an instance like this about the risk to nursing home residents and their families when they're presented with an arbitration agreement when they first move into a nursing home or long-term care facility. What does that exchange look like? What's the discussion that takes place? What is offered to them at that moment?
Thank you for the question. So I haven't I'm not there yet personally, though my parents are getting older and they live in your district. So thank you for your representation. But this is how I think it works. You're looking for a nursing home for mom and dad, and you're thinking about a lot of things. There's a lot going on in that decision. And when you bring them in and you're filling out these admission forms, the last thing you're thinking about is that this place that you are entrusting with your parents is going to engage in harmful behavior, negligent behavior. And so I think, as with so many of these situations, arbitration is forced upon us at the moment when we need the service or the product or the job, and we're not thinking that something terrible is going to happen down the line that's going to require us to go to court. And if I could just take a moment, I just feel like Mr. King keeps saying that that I'm misrepresenting his views, and I have to say, I think he's misrepresenting the facts. There's no argument that any serious economist believes that arbitration is better, faster, cheaper for consumers and employees as compared to class actions. And even the CFPB, as well as lots of economists, have proven that. But this, talk about old and tired, this old and tired Chamber of Commerce view continues to infect this conversation, despite just so much data on the other side. And I guess I just wish Mr. King would read the real studies as opposed to the studies that the Chamber gives him.
Professor Gillis, I just want to get back to this moment when the family is making a decision about a long-term care facility. The arbitration clause, is it a separate document? Is it inside something else? There's an admission packet, obviously, that has lots of paperwork. And this is a difficult time for someone who needs nursing care and their family, correct? I mean, how does that impact the fairness of agreeing to keep disputes out of court?
Right. Well, so we're not thinking about the court at that moment, right? We're thinking about mom and dad. And so these provisions, like all forced arbitration provisions, are hidden in the fine print of really long documents that you have to read. But none of us really reads. I think even lawyers don't really read these documents as carefully as we should, because we need to do this thing, this really traumatic emotional thing of putting our parents into what we hope is a safe place. So again, I think it's a fraught situation, and I don't think that most people know the rights that they're giving up at that moment.
Professor Gillis, I appreciate that. I thank the chairman for shining a bright light on the abuse of arbitration, the unfairness of these agreements that are forced upon American consumers. And I thank Congressman Johnson for introducing the FAIR Act to remedy this injustice, and yield back the balance of my time.
Gentleman's time has expired. I'll now recognize the gentleman from Florida, Mr. Stubbe, for 5 minutes. I'm sorry.
That's fine. Thank you, Mr. Chairman. First, my questions are for Mr. King, but what I'd kind of like to address is something that I don't feel is accurate that Mrs. Gillis had stated, that we're forcing an arbitration clause on an unknowing person. We have freedom of contract in this country. You're entering into a contract that has the arbitration clause. So to state that the person is unknowingly entering to these arbitration clauses is not factually accurate. Now, they may not read the clause in the contract that they are signing, but that's not to say that they're unknowingly entering into these agreements. So first, Mr. King, I'd like to if you could address those issues as it relates to these are parties on both sides of a contract that are entering into an agreement pursuant to contract law where these arbitration clauses are housed, so they're not unwillingly entering into these agreements. So if you could address that first.
Well, you're absolutely right. I mean, people enter into all kinds of agreements, and they do so on a willing basis. You don't have to purchase X, Y, or Z. You can go to another vendor. But Congressman, if I might, just one moment, I want to rebut what was misinformation here about the United States Supreme Court.
Absolutely.
The Kindred case was decided 7-1. DirecTV 6-3, Justice Breyer. American Express decided 5-3, Justice Kennedy in the majority. The Nielsen case 5-3, Kennedy in the majority. The Gilmer case, 6-2. It's just inaccurate. We're getting so much inaccurate information here. I'll put my stats up against anybody's. I'm not relying on the U.S. Chamber of Commerce, although I think they've done a great job in this area. But back to your questioning, let's not take away the freedom of contract. People have a right to sit down and negotiate agreements. They cannot negotiate illegal agreements, and they cannot force people to give up rights. It's just inaccurate to say that you don't have a right to take your case to the EEOC, the NLRB. And I dispute the Congressman's position that those agencies don't care about people that file charges. They do. They do a much better job in many cases than the courts, frankly. So we need to preserve the ability of people to work out disputes without being thrown into a morass of discovery, expensive litigation, and all the like.
Yeah, here in Florida, we haven't had litigation and trials due to COVID for over a year. They're setting trial dates right now in my district that are in 2022 and 2023 because litigation has been suspended in court and trials have been suspended in court due to COVID. So to say that you can quickly get into court and litigate those cases, especially with what's going on with COVID in our country right now, is also not factually accurate. Could you give us, Mr. King, a sense of the pros and cons of a typical arbitration compared to a typical lawsuit from the standpoint of an average American so that they can understand the differences?
Certainly. Lower filing fees, if no filing fee to file arbitration. Filing fees to get in court, expensive retainer agreements, even to retain counsel. So just the entry in the system is much higher in the judicial system. Second, speed to get to trial. As you've noted, in my testimony at page 4, I note the overwhelming burden on our federal courts, let alone COVID-19, as you point out. So you get to a hearing much quicker. It's inaccurate, as the professor noted, to say that there's no discovery, just the opposite. The American Arbitration Association rules permit discovery, but you don't get bogged down in these motion fights. If you want to see a waste of time and money, look at some of the discovery fights, and I'm sure you're aware of this, that go on in courts. So you get through discovery quicker, you get to a hearing quicker, and you get to a judgment quicker, and you do better. The Consumer Benefit Protection Board clearly showed that class actions are a sham, that the average amount of recovery was minuscule, $32 in the 2015 report, and only 13% of class action participants even got a payout. In arbitration, as the other congressman said in his practice in this area, arbitrators tend to split the middle. They're much more friendly, frankly, to the claimant. So the claimant does better, but by and large, it's a system they can participate in. They don't need a lawyer. They don't need to hire expensive counsel. And we ought to be talking about ADRs. I'm again surprised that none of the other witnesses are even recognizing the advances that are being made outside of the judicial system to solve cases. So the Supreme Court and many, many other courts have recognized the attributes of arbitration. Final point I'd make on publicity and the public nature. California now requires all arbitration outcomes to be filed. Other states are moving in that direction. There's not secrecy here. There's efficiency, cost savings, and certainty of getting a result.
Gentleman's time has expired. I'll now recognize the gentleman from New York, Mr. Jeffries, for 5 minutes.
I thank the distinguished chairman for recognizing me as well as for your leadership in this very important area. Mr. King just made an observation about individual litigants in an arbitration hearing not needing a lawyer. That seems to me to be laughable. If you're up against a Fortune 500 company, a Fortune 1000 company, a mega corporation who will be lawyered up to the teeth, how can an individual litigant in an arbitration context even expect justice without an advocate on their behalf? Professor Gillis, is it fair to say that in many instances, these arbitration clauses, which are buried in take it or leave it contracts, are akin to what we might refer to in the law as contracts of adhesion?
Yes, they are. This is forced arbitration. It's sort of it's tucked into the fine print that the last congressman said, is a contract, but I think that that's a fiction, right? Standard form contracts are not consensual. When I need to get the newest version of iTunes and I get a pop-up on my screen that says, do you agree to these terms and conditions? And the terms and conditions include an arbitration clause. It's really complex. I click accept because I want that new version of iTunes. To call that consent, I think that's what's laughable, frankly. That's a fiction. It's a convenient legal fiction for big business. But when it harms consumers and employees, I think we really have to step back and be clear that this is no longer consent.
Thank you. I think Mr. Weiss spoke to this in terms of your experiences. And so, Mr. Weiss, do you feel as though you had a choice in terms of your small business and the online platform that you were utilizing as it relates to declining to participate because of an objection that you had to being compelled to resolve disputes in arbitration?
Thank you, Congressman, for the question. No, the answer is clearly not. I had no choice, as I described in my testimony. If I wanted to sell on Amazon, which any e-commerce company has to in order to be viable with the amount of control that Amazon has over the e-commerce space, I only had one choice, to accept or to go out of business. But I also wanted to speak for a moment in terms of what you alluded to in terms of going into an arbitration without an attorney. I can tell you in my experience, Amazon came with 4 to 5 very seasoned attorneys practicing 20 or 30 years, senior partners at one of the largest law firms in Seattle. There would have been absolutely no chance that I had if I would have been representing myself without an attorney.
Thank you, Mr. King. I presume that you believe, as I believe you indicated in your opening statement, that women have a right not to be sexually harassed in the workplace, correct?
Mr. King, cut your microphone on, sir.
Sorry, pardon me, Mr. Chairman. To even suggest that those that propose arbitration procedures condone any of that type of activity is repugnant to me. Employers don't condone that activity, period.
Yeah. You may not have heard my question. I'm not sure if your audio was also not working. I said, I presume you believe that women have a right not to be harassed in the workplace. And I also presume that you believe that people of color have a right not to be discriminated against. Part of the concern, as I understand it, Mrs. Carlson, is that these provisions actually foster a toxic culture where this type of activity is buried underneath the sand, as opposed to being addressed in a more compelling, comprehensive, and public way, which is why it does facilitate the continuation of this type of aberrant behavior. Mr. Carlson, could you speak to that particular concern that I believe many advocates of this legislation have?
Congressman, thank you so much for the question. 100% correct, because other women don't know that it's happening to other people because of the secrecy. I'd also just like to rebut what Mr. King said. Apparently he knows personally about my particular arbitration contract with Fox News, but I'd like to read from that to prove the point about confidentiality. It says right in the agreement, such arbitration, all filings, evidence, and testimony connected with the arbitration and all relevant allegations and events leading up to the arbitration shall be held in strict confidence. It also says that any papers filed will be filed under seal. To that end, my story could not be public. So I want to make sure that I state that, and that's what thousands of other people are facing as well. Really,
The
this
gentleman's
comes
time
down
has
to
expired,
what-
but the gentlelady will be allowed to wrap up her answer.
Thank you. Thank you, Congressman. I would just say this comes down to choice, and you don't hear anyone on the other side describing that. Why do we have to force this? Why do we have to force this on people? Why don't we give them a choice?
Thank you very much. Appreciate your advocacy and your testimony and that of the other witnesses.
Gentleman's time has expired. I now recognize the gentleman from North Carolina, Mr. Bishop, for 5 minutes.
Thank you, Mr. Chairman. I've listened with interest to the hearing thus far. And I think one of the things that seems to be at play is that this is a question that requires some balance. And I think the panelists as a whole, I'm not sure we're getting all of the perspectives that are at hand. Let me explore it just a little bit. Mr. Weiss, I'm going to pick on you just a little bit, sir. I appreciate, by the way, there's no love lost by me for your nemesis, Amazon. It is operated by one of the most generous far left donors in politics. But I pulled it, and I celebrate, sure, your success in creating a business. I pulled up your website though, and you've got terms and conditions there. They don't contain an arbitration clause, but they do have provisions. There's a provision, the forum selection clause, that would require somebody using your site to bring their lawsuit in a Massachusetts federal or state court. There's a contractual limitations period requiring them to bring their lawsuit within a year. You've got disclaimers of warranties in order to limit your liability. You're not trying to abuse consumers in having those sorts of provisions in your terms and conditions, are you, sir?
No, of course not.
And I think if you were susceptible to being sued in state or federal court in 50 states, would that make it harder for you to be able to survive as a startup business, building your enterprise?
Look, I'm not an attorney, so I'm not exactly sure, if how it would play out. So I don't exactly know how to answer that question. But to your point, we're set up to do business and try to service our consumers and try to offer the best service. And hopefully we never have to be sued. We don't have arbitration. We haven't been sued a lot. We have been sued not by consumers, primarily, collections partners and stuff like that. But we're clearly, in business to try to offer a service and a product for our consumers. That's what our focus is.
And Mr. Weiss, obviously you're building something that people value. And I'm sorry, as I said, I sort of have to pick on you, because the point is, many times if you're a consumer to Amazon, but you're a seller to others. And so the utility of some of these things, I think, can get lost when people are focusing on highly emotional, just on one side. And so as I said, sir, I didn't mean to pick on you, because I think we need to celebrate people who are building businesses that serve us all. And I think it's important for us to reflect on the fact that, take the nursing home example Mr. Deutsch used, how many people would be harmed if there were no nursing home, because the risk environment were such that the business couldn't exist? And so there's great utility, arbitration agreements. I've been litigating with arbitration agreements for 30 years. And I've seen some situations in which I didn't think it was great, but I think you have to proceed with great caution when you're throwing all this to the wind. There's a risk of throwing the baby out with the bathwater. And I wonder, Mr. King, just on that perspective, I'd ask you if you have any comment on the point I just made that you'd like to offer in my time remaining.
Absolutely. The disruption factor for millions of individuals that do use arbitration, businesses that use them, would be tremendous, particularly if the FAIR Act is construed to be retroactive. I just want to share a figure. As of September 30th, there were more than 650,000 cases pending in our federal district courts. Now, the nursing home example, the presumption is if you took those cases to arbitration, the claimants would be treated unfairly. How do you know that? You don't know that. In fact, they may receive even more money. See, that's the presumption we're dealing with here. People presume that they're not going to get a fair deal in arbitration, yet they have no experience with it, or they make assumptions that are not supported by facts. Claimants do better in arbitration. So I would suggest to you, in the arbitration setting for nursing homes or other situations, arbitration can and will work. We can take secrecy out of it. I've already addressed that. That's a misnomer. That's a red herring. Secrecy and mandatory arbitration are not one and the same. In Ms. Carlson's situation, it's a perfect example. Yes, I know of your clause. I read it carefully. I know a lot about your case. The fact is, you were able, notwithstanding that case, to publicize your situation throughout the world. In this day and age we live in the platform economy, and the ability to instantly communicate, People know if they're being treated fairly or not. So to suggest that you were muzzled, of course, is incorrect. We know that's not the facts. We need to get people involved in litigating disputes in a way that makes sense, is less costly, more efficient, and more expeditious. And alternative dispute resolution procedures and arbitration are the way to go.
The
Not
gentleman's
forcing
time has
everybody
expired.
into court.
Gentleman's time has expired. For the record, the FAIR Act applies only to forced pre-dispute resolutions as opposed to after the dispute arises. And with that, I will now recognize the gentle lady from Washington, Ms. Jayapal, for 5 minutes.
Thank you, Mr. Chairman. I just would like to remind everyone who may be listening out there about what forced arbitration really is. When was the last time you read the fine print of the paperwork required to buy a cell phone, to rent a car, or to accept a job? For most people, the answer is probably never. Not because of negligence or irresponsibility, as Mr. Stubbe suggested, but because people don't know that these forced arbitration clauses are there, and it would take hundreds of hours for anyone to actually read and understand these provisions, on top of the fact that they are in these agreements that people desperately need, like job agreements. So these provisions that powerful corporations have tucked into the fine print have forced workers, consumers, and small businesses to waive their constitutional right to seek justice in a court of law and allowed for the stealing of $12.6 billion from workers in 2019. And as Ms. Carlson has so powerfully pointed out, these forced arbitration clauses allow women who face sexual harassment to have few alternatives to fight back. And thank you, Ms. Carlson, for your work. I was proud to be a lead co-sponsor of the bill in both of the last two Congresses. Meanwhile, the regulatory agencies are so influenced by the corporations they're supposed to regulate that they haven't exercised their authority to fix the situation, contributing to the worst levels of economic and political inequality in over a century. Mr. Weiss, in your testimony, you describe how your business was forced to spend thousands of dollars, tens of thousands of dollars, in a costly and lengthy arbitration proceeding after Amazon charged you significantly more for shipping than your agreement with the company allowed. Forced to go through arbitration, you recovered very little of what you lost. How difficult is it for anyone, much less someone with even less resources than you, to be successful in forced arbitration against a giant company like Amazon?
Thank you, Congresswoman. The answer is it's probably almost impossible because it was very difficult for us with the limited resources that we do have to get up against a very large organization with a very powerful group of lawyers that was very successful in being very litigious at every stage of the game. So from the very beginning, arguing about even at which table we should sit. Everything was a hearing. Should we sit in Florida? Should we sit in Washington? And then and it just continued to go on and on and on. And in what was a very, very simple, we agreed to A, you charged me B, and you owe me the difference. It dragged out for over 16 months and tens of thousands of dollars in cost. Not even cost. I mean, when I said over $50,000, that was just the arbitration cost. The AAA charges you based on a sliding scale of the value of your damage. So if your damage is $100,000, you pay a lot more than your damage is $50,000. It's almost like you have another partnership in the arbitration as a partner in your claim. And so I can't even imagine how somebody without the resources or a lot less, much lower amount of resources that we were having, how they can even begin a process.
Thank you, Mr. Weiss. And Ms. Gillis, as one of the foremost experts on class action litigation, how does Mr. Weiss's experience compare to what you see across the country? How easy would you say it is for the average employee or consumer or small business to file a lawsuit by themselves against a powerful corporation when their rights are infringed?
I think Mr. Weiss is exactly right. It is difficult. Even if we set aside forced arbitration, there are problems with accessing justice in our ordinary civil justice system. And, maybe Mr. King and I can agree on this. The court system is not perfect, but it is our system that we have used for a couple of centuries. So I'm confused by why other members of Congress want to reform this other system called private arbitration. We should be fixing the system we have that taxpayers actually subsidize and make it easier for people, ordinary people, to access that system. And I think there are lots of ways we can do that, but I'm not sure why we should put energy into this big corporate arbitration procedure when we have a system of our own that is public and available and reformable. We can fix it.
Thank you. A 2020 study by the National Employment Law Project projects that by 2024, 80% of all private sector non-union employees will be subject to forced arbitration requirements.
The gentlelady's time has
like
expired.
the ones Mr. Weiss was subject to. Thank you, Mr. Chairman. I think this is a very important issue that we're taking on. I yield back.
I thank the gentlelady. We will next hear from the gentleman from Indiana. Excuse me, the gentlelady from Indiana, Congresswoman Sparks, for 5 minutes.
Okay, well, okay, thank you so much. Thank you, Mr. Chairman. I think it's interesting because I have a little bit different explanation and definition of forced arbitration. I personally CPA, so I'm not an attorney, but I've been a legislator for some time. And I get very surprised to see when we put arbitration in our law, we're forced the stakeholders to go to arbitration versus to the court system. The great example is a recent surprise bill in law. We were forcing arbitration of stakeholders, and I do not like it, and I've seen it in our state code. I generally look at arbitration as the freedom of contract, and it's a very important freedom if we want to have a free society and have free markets. But I have to agree with some of people here that there is some monopoly power. I've been involved in Fortune 500 world, and I can tell, Amazon's, Google's, Facebook's of this world have a lot of power. So we need to make sure that the contracts are transparent. So as I understand, the court system generally does not enforce unfair clauses. But there is something in the law, and I would like to ask Mr. King, since he's a professional and he's a practitioner of that law, is there something in the Federal Arbitration Act that needs to be improved to make sure that reasonable, unfair, and biased clauses are not enforceable, and make sure that we can improve transparency versus eliminated arbitration? Because if we think that these big monopolies, oligopolies have less power in the court system, we are very naive, because the same attorneys are going to be there, and it's an even more complicated and expensive system. It's going to hurt the little guy at the end. And someone like the gentleman was talking, dealing with Amazon, he will have even less ability to deal with them. But as a small business owner, it would be tougher to actually to deal in the court system too. So is there anything that could be improved in the act, Mr. Keaton?
Well, good question. Right now, the law is quite clear, I would submit. If you are forced into an agreement by adhesion, coercion, subterfuge, deceit, fraud, those agreements can be set aside and are set aside. I'm not sure we need to amend the law, but that's certainly something we can look at. I also want to just build on your question. We keep hearing this fine print and people being subject to things they've not read or don't understand. How many people in this discussion we're having today could point to anyone that has read the federal rules of civil procedure and all the procedural rules at the state level and the courts? You talk about legalese, difficulty to understand, complexity. It's far more in the federal courts and the state courts than you ever see in arbitration agreements. I don't understand Mr. Weiss's situation. Is he suggesting he would have been better off to go with the court? Does he think, as you just mentioned, that the company will not come with good legal talent to a court? Does he think that somehow he's going to be advantaged to being in a court? I would suggest just the opposite. He's going to get a much better situation with an arbitrator. And the final thing I'd like to say about the Amazon case, just to make sure we have a level set of discussion here. I was told early on in my legal career, I know by one of my best law professors, if you only hear one side of the case, you are not doing justice to the discussion. And I'm sure there's another side to this discussion that we haven't heard. But let's not fool ourselves. You're absolutely right. We need to look at alternatives, Congressman. We need to look at ways of improving the system. Let's still don't eliminate it. If we put 80 million people in our court systems to try to have a day in court on jury trials or even judge trials, it's not going to work. So let's be realistic in this discussion.
Well, thank you. And maybe if I have for Professor Gillis, if there is something from your perspective, you can say in the law that could be done to improve transparency, and so we don't have a distortion of power. And if you can comment on that.
I'm sorry, Congresswoman, can you repeat the question? You were fading in and out.
Sorry, I need to have better internet connection. I'm just saying, do you believe in the Federal Arbitration Act? Is there something to need to be improved to make sure that unfair clauses are not enforceable and there is no distortion of power from large monopolies in these clauses, or you think it is addressed in that act?
I think we can fix arbitration, and the only way I can see to do it to make it fair is to offer consumers and employees the right to go to arbitration after a dispute has arisen. Providing choice post-dispute is voluntary, right? At that point, it's not forced upon us. We're reading the print, and we can make an educated decision about whether to go into arbitration, which, if Mr. King is right, it's awesome. We should go to an arbitration, or to go to court and be represented in a class action. And it might also provide individuals with the ability to negotiate for better arbitral procedures because they're choosing to go to arbitration.
The gentlelady's time has expired.
Thank you.
Thank you.
With that, I would like to now recognize the gentlelady from Florida, Congresswoman Demings, for 5 minutes.
Thank you so much, Mr. Chairman. Let me say you're doing an exceptional job. As someone who has worked hard a large portion of my life to take care of people and to protect people, I struggle when I hear some of my colleagues push so hard to put the interests of corporations over the interests of people who work hard to make those corporations great, especially when we know, just listening to this hearing, but others as well, that many of those corporations are not operating in good faith. As a former police chief, I have participated in numerous arbitrations, but the decision to go to arbitration was solely that of the employees in consultation, in that case, with their union representative. I think when arbitration or decisions in arbitrations are final and binding, it does make a difference when they are voluntary. Professor Giles, thank you so much for your testimony today. And I would just like to ask you, does a person forced into arbitration have the right to appeal an arbitrator's decision when it is incorrect as a matter of law or fact?
There are very limited grounds for challenging an arbitral decision under Section 10 of the Federal Arbitration Act, but you have to show that the arbitrator acted in, quote, manifest disregard of the law. I'm sure, as you can see from the way I described that is a really high hurdle. And given that arbitrators don't even often tell us what they're basing their decisions on, they don't write written decisions. They're not paid to write precedential decisions. It can be almost impossible to meet that standard. So I think this is not a real appellate right.
Thank you so much, Dr. Giles. And it's interesting that I heard earlier that many times in arbitration, you get a fairer deal. And so that just makes me wonder why the arbitration has to be forced if you can 9 times out of 10 get a fair deal. Ms. Carson, I want to thank you so much for your very powerful testimony. And thank you for being with us today. In your view, would requiring the arbitration or requiring that arbitration is truly voluntary address some of the concerns that you have addressed with us today?
I do think that this comes down to choice, Congresswoman, so thank you so much for the question. Let's just be realistic. Companies don't want you to know their dirty laundry. So that's why they force arbitration onto women, especially with sexual harassment. So if it was a choice, that would be a totally different power balance. You know, here you have the person who's forcing arbitration. Here you have the woman down here without a voice. I'd also just like to respond to Mr. King again that, yes, I had the platform and the resources to make my case public, but I would have been forced into arbitration, Mr. King, unless the courts wanted to do something incredibly provocative 4.5 years ago. And it's also interesting, Congresswoman Demings, that Mr. King does not bring up the statistics with regard to sexual harassment victims who go into arbitration. Because number one, we have no way of knowing how many thousands of women have been forced into arbitration in silence for forever. We do know that the stats show that employees only win less than 3% of the time. That does not sound to me like it's fair.
And Ms. Carson, I know that this committee, the full committee, perhaps does not want to hear this, but I want to, and I think it's very important. As a nation, we've come so far as it pertains to women's rights and fighting against discriminatory practices, but we are nowhere near where we need to be. Please tell us again, so we can have a clear understanding, how does the arbitration process silence sexual assault and harassment survivors? I want to hear it again.
Congresswoman, thank you. The minute that you go to HR and you have an arbitration clause, they go, no one's going to know about this. And immediately they go into action. They put you into the secret chamber and you are all alone. And you have no way of knowing that there's anyone else at work going through what you're going through. And
please.
Yeah, so and ultimately what ends up happening is you get fired and the perpetrator gets to stay on the job and the woman never works again. And especially during these times when we've lost 1 million women to the workforce during COVID. And we know that retaining women increases the bottom line of companies. That's why I'm asking this committee to take this seriously.
Ms. Carson, thank you so much. And we know that any company that would practice that is not operating in good faith. Mr. Chairman, I yield back. Thank you so much.
Thank you, gentle lady. We will next hear from the gentleman from Oregon, Mr. Bentz, for 5 minutes.
Thank you, Mr. Chair. As a lawyer, a practicing lawyer up until just a couple of months ago, for well over 30 years, I can share with you the many times I've sadly told prospective clients that we could not take their case because the amount involved was simply too little to justify the amount they'd have to spend. And over the 30 plus years that I practiced, I watched the cost of litigation go through the roof. And this is why we see so few cases actually making their way into court. And not to mention the fact that the level of competence required to try cases has dramatically increased, and you better know what you're doing if you're going to go into court. But having said that, we've heard a lot of really interesting things today. I'm much more knowledgeable now about arbitration than I was before, even though I've served as an arbitrator. But I would like to turn the balance of my time over to Mr. King to let him address issues that perhaps he thinks could use a little more elaboration. And in particular, I'd like Mr. King to address this concept of why or why not we should wait until after a dispute has arisen before making a choice to arbitrate or not. So thank you, Mr. King, if you could take it away.
Thank you very much, Congressman. Post-dispute arbitration doesn't work. It's a non-starter. I know at first blush it may sound attractive, but once the dispute has developed and once the parties are in adversarial positions, trying to put the pieces back together again just doesn't work. So it sounds good, but it doesn't work. And that's been proven time and time again. You need to have some orderly way that's agreed upon up front. You can't change the game. You can't change the rules as the dispute is evolving and going to some type of contested action. Second, filing fees. There's a lot of misinformation so far being shared, unfortunately, with the subcommittee. The American Arbitration Association limits filing fees for consumers and employees to $300 or $200 very low. Many company arbitration systems pay for the filing fee altogether, also pay for the attorney's fees if an attorney is needed by the claimant. In fact, in the professor's testimony, on one hand, she criticizes companies and the cost of getting into arbitration, but then she shows how the arbitration system can work, where there's a lot of arbitrations filed and companies are having to pay these fees. I mean, you can't have it both ways. So that's a misnomer. There's a very low entry level financially to get into arbitration. As far as limited opportunity for appeal, that's one area that I can't agree with the professor on, but it works both ways. If the employer doesn't do well in arbitration, isn't pleased with results, it also has very limited opportunity to appeal. And as you know, as an arbitrator, the arbitrator has tremendous authority to set an award that generally will not be set aside. And, you know, the win rate issue here really needs to go back into the discussion. We don't have to have litigation. We don't have to have jury trials. We don't have to have mandated arbitration necessarily. Why not talk again? And nobody seems to want to talk about this, about alternative dispute resolution. You as a former arbitrator, I'm sure probably did mediation. And there's all kinds of other ways that consumers and employees, and the union environment's a perfect example. People can sit down and work out their differences and conflicts can be resolved. Putting everybody into the courts, let alone a class action system, isn't going to work. And no one seems to want to address that. I just shared a stat with you. I can share stat after stat that are verifiable, that our nation's courts are overburdened. You know this from your practice, I'm sure. Filing a complaint is the first step in a lengthy, perhaps multi-year process. And to suggest that there's any kind of swift justice is just not accurate. As I say in my testimony, justice delayed or justice not available is certainly justice denied. Arbitration can work, it has worked, and it will work. And to paint it as some type of system that promotes discrimination against women is absolutely dead wrong. I really take offense at that. Somehow to suggest that employers in this country that use mandated arbitration condone any type of sexual harassment, hostile work environment situation, or unfair treatment of consumers is absolutely unfair. That's not where we are. In this society we live in today, if an employer mistreats an employee or a consumer, word gets out on the internet instantly. Companies are concerned about their reputation. They are doing what's right. We're very involved in diversity and initiatives, inclusion initiatives.
Time has
so
expired.
let's not paint the picture in the incorrect way here.
Gentleman's time has expired. I'll now recognize the gentle lady from Pennsylvania, Congresswoman Scanlon, for 5 minutes.
Thank you, Representative Johnson, and thank you for your introduction of the FAIR Act, a bill I've co-sponsored and enthusiastically support. I'm really happy that we are dealing with the subject of ending forced arbitration because it's, particularly in this financial climate, it's an important issue for my constituents. Pre-dispute arbitration agreements are now in all of our lives, and many of us don't even know of every instance in which we've agreed to them. A 2015 study by the Consumer Financial Protection Bureau found that 53% of credit card issuers, 88% of mobile wireless providers, and 99% of payday lenders include forced arbitration in their contracts with consumers. American markets are so saturated with these unfair contracting terms that in many instances consumers have limited, if any, other options for fairly contracted products or proper judicial recourse if something goes awry. You know, in a world built increasingly around mobile phones and credit, giving up your fundamental right to trial by jury is all but mandatory in order to participate in our modern economy. My colleague, Ms. Jayapal, highlighted the fact that many of these contractual clauses are contained in fine print. But what really is a problem to me is the fact that there's just no choice. As a lawyer, we call it a contract of adhesion, but in plain English, basically the company has you over a barrel. So I'm particularly concerned about the use of forced arbitration agreements in private student loan contracts. That same Consumer Finance Protection Bureau study that I mentioned found that 86% of the largest student lenders in the private student loan market employ the use of pre-dispute arbitration clauses in their contracting. So American borrowers have over $1.7 trillion in student debt at this point. And my home state, Pennsylvania, has one of the highest per capita debt loads in the US, an average of $36,000 of debt for our student borrowers. So we're left with a system in which students who need private loans are forced to decide between waiving their rights or getting a degree. Now, the Obama administration and the CFPB issued a set of rules banning the use of forced arbitration, including in private student loan contracts. But the Trump administration and the then Republican majority in Congress repealed those protections in 2017. Although I expect the Biden administration to lead a shift back towards protecting students, we need to legislate permanent protections for those borrowers. And that's why this morning I reintroduced our Justice for Student Borrowers Act, which would codify the ban on pre-dispute arbitration clauses and pre-dispute joint action waivers in private student loans. And I'd like to thank my colleagues, many of whom are on this committee, for joining me in introducing this legislation. So, Ms. Giles, you talked about the ubiquitous of forced arbitration clauses in private student loans in your testimony. While we know that many private student lenders are failing, if not bilking, their borrowers, is it wise to allow those lenders to shield liability with forced arbitration clauses?
No, it's not. And I want to thank you for introducing the Justice for Student Borrowers Act. This is incredibly important, in large part because it has effects that are disproportionately felt among low-income and minority communities who are trying to improve their lives by getting these degrees, by sort of moving up. And are then sort of saddled with terms that are often unfair. And when they try to dispute those terms, try to get relief, they are shunted off into arbitration. And I just want to spend a second going back to something Mr. King said when asked about why post-dispute arbitration is not workable. I think he sort of punted and said, well, it just doesn't work. Well, there's no reason to think it doesn't work if arbitration is as great as people like Mr. King say it is. Then maybe some employees, consumers, student borrowers would choose it after a dispute arises. But I don't think it's fair to simply say that it won't work. And the only way to make arbitration work is to force it on an unknowing public. And I will just continue to say that we are indeed companies are forcing these provisions on the public. So, Congresswoman, thank you again for your leadership on this issue. I think it's really important.
The gentlelady's time has expired. And with that, we will now hear from the gentlelady from Minnesota, Ms. Fishback, for 5 minutes.
Mr. Chair, thank you very much, and I will yield my time to Congressman Issa for as much time as he may use.
I thank the gentlelady. Having worked with Ms. Carlson for so long and watching what happened, I think all of us saw a terrible series of events that depicts a lot of what goes on behind closed doors, not just at her employer, but employers all over the country. And certainly the so-called casting couch in Hollywood is famous for sexual harassment that went unreported for years. So, Ms. Carlson, let me ask a couple of questions in light of that. And I'm not trying to be harsh on you, but I just want to frame your situation versus so many people that find themselves in a similar situation. In your particular case, you had a contract with your employer, correct?
Yes, I did.
And you had renewed that contract at least once, right?
Yes.
And you were represented by attorneys when you negotiated that contract?
An agent, yes.
Okay. So you were a sophisticated negotiator, but you still found yourself with provisions that limited your ability to seek remedies when you were sexually harassed.
Exactly. And even with the Stanford and Oxford education, I did not understand the ramifications of arbitration when I signed the last contract when they put the clause in there.
Well, having gone to Kent State, I'm not going to badmouth Stanford. Just not going to do it here. But let's go through a couple of things that are related to your case, but I think it may be part of the solution that we all need to look at in Congress. In your particular case, you made a decision rather than to sue your employer, where you did have the non-disclosure and so on, you sued the individual who harassed you and attempted to get your day in court. Is that correct?
Correct, because there happened to be a law in the books in that particular state that allowed my attorneys to do that. But that law does not exist anywhere else.
So, to a great extent, since sexual harassment is by definition primarily an act of somebody to somebody else, although it can include a company, if you will, culture, but the individual acts are individuals. If Congress viewed that as a right to sue an individual that would not be and could not be placed in your employment contract with a company, that would have put you into a situation on a national basis where you would have had rights to go after the individual for their individual acts.
Potentially.
So, as we're looking at remedies, is that a remedy that you would maybe think a little bit about and opine on at a later date? Because I would like your input, because I do think that there's such a difference between the what companies try to protect themselves from, which is often class action suits, versus both the secrecy that they're not entitled to and the individual acts that often are protected. And I'll note that it's often protected at EPA, at OSHA, at government agencies, because it's not just private corporations, but our federal government and state governments city governments often have rampant wrongdoing by individuals who are sheltered.
Yes, but I would just want to point out that this is pervasive across the board from every socioeconomic class and every profession, which I didn't even know about till I filed my case. And the reason I didn't know about it is because it's all in secrecy. I mean, that's how you don't know about it. Again, so I would also say that the companies have a huge responsibility to make sure that they are not allowing this behavior to continue. And as long as it can continue to go to secrecy, they are allowing it to be systemic. So it's much more than just the individual.
And I want to join you in trying to stop the secrecy. I think we've certainly had hearings in the past on priests in the Catholic Church. I certainly think if we're going to go after individual priests, we need to go after individuals wherever they are. One last question for Mr. King. What is the, if you will, the history or the quantity of people who do have a choice to opt for arbitration, choosing to do so, both plaintiffs and defendants, both employers and employees? When that's an option, is it chosen with a great deal of regularity and also mediation? Would you opine on the good of those programs?
The gentleman's time has expired, but I will allow Mr. King to give a short answer to that question.
There is a very heavy use of arbitration mediation for represented employees and under union contracts. It's pervasive. The same is true for non-union employee situations, and the usage factor has gone up considerably in the consumer area.
Thank you, and I thank the gentlelady from Minnesota for yielding.
Thank you. I now recognize the gentle lady from Georgia, Mrs. McBath, for 5 minutes.
Thank you so much, Mr. Chairman, and thank you to each of you that are here today. And I want to start by being really crystal clear in what we're talking about today. The FAIR Act is about ending forced arbitration. My office is still being contacted by groups that are spreading so much misinformation, and I want all of my constituents, if they're listening today, the employees, the small business owners, and consumers that I represent, I want you to know this. Passing the FAIR Act is about making sure that you have a choice. It is about making sure our courthouse doors remain open to all as they place to seek justice. And so nothing in the FAIR Act will prevent you from seeking some other dispute resolution process, including arbitration, if you so choose that. But it is critical that no one is forced out of court before their case, their claim, or their mistreatment even arises. And so now turning to you, Mr. Weiss, you built your business from the ground up, as you told us. In your written testimony, you said that before Amazon would let you sell anything on its marketplace, it forced you to sign what it calls a business seller agreement. You added that you had no ability to negotiate the terms of that agreement and no ability to sell on Amazon without signing that agreement. Can you explain, and you did kind of touch on this a little bit, earlier, that, you felt like you were forced into signing the agreement, that you felt like you didn't have really any leverage to reject the forced arbitration session of the contract. So what do you think would have happened if the outcome, in your outcome, if you agreed to accept all the terms in Amazon seller agreement, except for the forced arbitration provision?
Thank you, Congresswoman. There isn't even such an option. It's a take it all or leave it all. So I didn't even have an option to take any portion of the agreement out in order to be able to sell on Amazon.
Thank you. And also in your written testimony, you said that forced arbitration puts third-party sellers in a lose-lose situation where they're left with this dismal choice of doing nothing in response to Amazon's wrongful actions or being subjected to the issues. How does it feel to be faced with a choice of doing nothing or continuing to be subject to the problems that you were facing? And what effect does your inability to obtain any meaningful relief have on your business and your employees?
Not a very good effect. As I also mentioned in my testimony, there's many claims that I've discussed that we've experienced as a seller, and I've discussed with other sellers that have experienced very similar issues. But because of the financial component, we just had to accept that outcome without even having a way to kind of rectify it, because the cost of pursuing arbitration to right that wrong was going to be so much more expensive that it doesn't just make financial sense. And so you just have to drop it and just take all of the, just live with all of the issues that you have to deal with that is completely unfair and unjust.
And I sense that grave unfairness that you're speaking about. So do you agree that the FAIR Act is necessary to stop the dominant companies like Amazon from facilitating and covering up any mistreatment of individuals and small businesses who are dependent on these companies for their very survival?
Absolutely.
Well, thank you so much, and I yield back the balance of my time.
Gentlelady yields back. At this time, I will now recognize the gentleman from Wisconsin, Mr. Fitzgerald, for 5 minutes.
Mr. Chair, I do not have any questions at this time.
Thank you. At this time, I would recognize the gentleman from Utah, Mr. Owens, for 5 minutes. Mr. Owens, going once, going twice. So at this time, I will now yield to the distinguished ranking member of the subcommittee, Mr. Buck, for 5 minutes.
Thank you, Mr. Chairman. Ms. Carlson, I want to visit with you about something, and I think that many of us agree that the area of sexual harassment is absolutely disgusting in terms of the scope and nature of it. And yet I find this particular legislation to be
sort of a one-size-fits-all, and it applies to a contract with a credit card company, a contract with a wireless carrier, and yet we have some really serious situations like sexual harassment that may be pulled out of. And I think the bill that you're actually advocating for, and the bill that Ms. Stefanik is advocating for in the Republican conference, is a more limited area of this particular arbitration issue that we're trying to address. And I think many of us would and I think I'm going to ask Mr. King next to comment, but I think many of us are interested in finding discrete areas that are so important that we should ban arbitration clauses, do it in a fair way to the employer and the employee, but at the same time not burden the courts and create additional costs for corporations and businesses in America that are sometimes unnecessary and would really increase costs for cell phones and other things. Would you agree with that generally?
Well, Congressman Buck, I really, really appreciate your comments and being willing to have an open discussion about this, because as I said earlier, this isn't a political issue. When somebody decides to harass you, they don't ask you what party you're in first. They just do it because it's really about power. And that's why I've been advocating so much to bring the parties together to try and solve this issue. And I would just say that the day that I found out what my arbitration clause meant was one of the darkest days of my life, because my lawyers told me you don't have a case anymore. And that was incredibly difficult to digest. I mean, if it hadn't been for their strategy to at least make my case public, I wouldn't be having this conversation with you right now. We arguably wouldn't be having this movement right now. So I want to be clear that I would have still been forced into arbitration if my case would have been not settled. And so I really believe that we have no way of knowing how many women this has affected and how many have been forced out of the workplace. And that is what's so concerning to me, is that all the thousands of women who reached out to me, they had one common theme, which was they were silenced. And they never worked again.
I don't mean to interrupt you, but I want to make sure that we talk about one other thing that I think is really important here. I find the secrecy component of your testimony to be very disturbing. And I think when there is a predator in the workplace, that person should be outed, the company should be responsible, and make sure that whatever line of business it is, that doesn't happen again. And avoiding secrecy, making sure that there is publicity, is one way of dealing with predators. The arbitration area is a little bit different than the secrecy area. And I just want to make sure you recognize and are willing to tell people who are listening today that there is a difference between the secrecy and the arbitration. The secrecy is really what is so offensive to me, and from your testimony, I'm assuming to you, the arbitration we've got to find ways of dealing with. But I think we can agree that there is no place for secrecy agreements when it comes to very, very serious conduct like sexual harassment.
Yes, secrecy is a central element. However, as I just read from my contract, that was part of the arbitration. And there are other women that I know of right now that are in arbitration that you never ever hear. It's like they become invisible because they're not allowed to tell their story. And that's how this problem continues.
And they should. And I think they can be separated. But I've run out of time. Thank you very much for your testimony, and I yield back.
Thank you.
Gentleman yields back, and I recognize myself for 5 minutes. Ms. Carlson, with the forced arbitration clause being buried in the fine print of your contract, would you have signed that contract if you had known that you were signing away your right to go to court for redress on your sexual harassment claim?
Never.
And Mr. Weiss, you've testified that you were forced into your agreement because there was no alternative platform, and it was a take it or leave it situation for you, and that's why you ended up in arbitration. Is that correct? You need to unmute.
Sorry about that. Yes, Congressman, that is correct.
Thank you. And Mr. King, you stated in response to the 3.5 minutes that Mr. Bentz gave you, you stated that corporations pay for the aggrieved person's lawyer if they need one. And you also stated that the corporation pays for the arbitrator. When the corporation is paying for the arbitrator and the attorney for the claimant, is that possibly why in arbitration only 3% of employees win their cases?
Well, there are many reasons for the outcome. In court,
Well, could it be
Mr.
because
Chairman,
it's a setup and the employer has paid for the result that they want and they get that result?
absolutely not. Absolutely not, Congressman.
Well, tell me this, Mr. King. What is so bad about allowing employees and consumers to choose whichever form of alternative dispute resolution, be it arbitration, be it mediation, or litigation? Why not leave it up to the parties to decide that once the dispute arises, as opposed to burying the terms, the waiver of your constitutional right to a jury trial, burying that in the terms of an agreement on the front end? What's so wrong with giving people the right to do things fairly with knowledge of what they're doing?
On the surface, that's a very appealing question, Mr. Chairman. The fact of the matter is they have those options today. In discrimination cases, they can file.
So when they have signed a contract that waives their right to go to court and they're bound to arbitration, how can they get out of that once they've signed the contract?
Well, it depends on the fact pattern, Mr. Chairman. As I was starting to say, if it's a discrimination case, they can file in a state or federal agency with the EEOC. There's no gag order. There's no confidentiality clause that would prohibit that. I mean, they have options today. The problem I'm having with this conversation is, what's the alternative? Everybody on the panel, except for me, is saying arbitration doesn't work. Well, what's your alternative? Are you going to put everybody in the court system? No, that doesn't work. What I would respectfully
Well, why
suggest
doesn't it work?
is have another hearing on ADR.
Why doesn't it work to go to an Article III court created by the framers of our Constitution as a means of protecting and preserving justice in this country? Why not go to court? What's wrong with that?
Because you can't get to court, Mr. Chairman, or you can't get there in an efficient way.
Well, I'll tell you something, Mr. King. It's been 30 years, 1990, since Congress expanded the federal court system and created new judgeships. It's been 30 years, and you and I know that commerce has exploded, the global economy has expanded, there are more disputes, and the courts remain essentially with the same numbers that they had 30 years ago. Aren't you in favor of congressional action today that would expand the federal judiciary and create more judgeships?
Well, that's certainly an option. The other options
would you support that?
Concentrate on alternative dispute resolution.
Would you support that,
procedures.
Mr. King?
It depends on what else is in the package. I would want alternative dispute resolution procedures to be endorsed by this committee and explored. I also would want federal district court vacancies that are currently unfilled to be filled. I also would like to see a reformation of the discovery system that we have and the rules of civil procedure. There's a lot that can be done to reform our current judicial system, Mr. Chairman. I think we could reach consensus on that. So there's a number of areas, but the answer is not just to eliminate pre-dispute arbitration. You're going down the wrong path.
All right, thank you, Mr. King. And I want to thank all of our witnesses for their appearances and for their testimony today. I seek unanimous consent to add a number of letters and statements into the record from organizations in support of ending forced arbitration and passing the FAIR Act. A statement for the record from Valerie Haney, one from Tanjua Gupta, a statement for the record from Remington Gregg, Counsel for Public Citizen, a letter for the record from Leadership Conference on Civil and Human Rights, a statement for the record from Heidi Silton, President, Committee to Support Antitrust Laws, a statement for the record from Chrissy Carnell Bixler, a letter for the record from Consumer Reports, and a plaintiff brief in the case of Newton versus Hennessy Louis Vuitton, for the record. Without objection, it is so ordered. And so, ladies and gentlemen, this concludes today's hearing. I want to thank you again for appearing as witnesses. And without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And with that, the hearing is adjourned.
Thank you, Mr. Chairman.
Thank you.
Thank you.
How is everyone doing? Doing a quick mic check.
Hi, this is Maria Elena. I can hear you well. Can you hear me?
Yes, I can. And one sec, I'll start the training one more time for you guys when one more witness comes in.
Hey, Troy, can you hear me in the room?
Yep, I can hear you good.
Excellent, thank you.
Yeah, the long term is where the battle is, but yeah, today was like,
And then I felt kind of bad because John like kind of stopped talking to me. So I emailed him thanks today, but he hasn't responded.
yeah, I sent him too.
I was like, thanks.
He never responded.
Yeah, he's probably, giving his thanks to me.
There's a hot mic in the room.
John, we love you.
Mic check in the hearing room. Mic check in the hearing room for the court reporter. Testing 1, 2. Oh, really?
Okay, it looks like 3 out of 4 witnesses are here. I'd just like to see if you guys are sitting by the computer right now.
Yes.
Kursenau here.
Okay, what about Peter Kirsnow? Okay, did you just say something?
Yes, I'm in my office.
Okay, cool. All right, I'm just gonna go through training real quick one more time. I'm sure you guys have had a call before this to run through things, but just wanted to keep you guys 100% in the loop. So first things first, you're going to want to make sure your background is good. If you guys are in an office space with not too much going on in the background, that's great. And also, good lighting is important too. We just want to see your face. Next thing will be the mute and unmute check. It looks like you guys have that figured out. Mute button is in the bottom left. And if you're not speaking, just keep yourself on mute, and just to minimize audio feedback. If someone else is causing feedback while you're talking, just keep going through it and we'll try to fix it as soon as possible. Next thing is camera on and off check. Your camera must be on at all times during the hearing. This is just to keep consistency as if this were an in-person hearing. And if you need to leave for an emergency, just let us know. You can hit up your judiciary point of contact and they should be able to call a recess for you. Just send them a text or an email and that'll be good. But yeah, we're just going to want to keep you in front of the camera at all times. It's as though if you're actually testifying in person. So we want to make sure that we can see you and make sure that you are who you say you are. One second. All right, next thing is bandwidth. Make sure everyone in your house isn't using any streaming services such as Netflix, video games. other Zoom interviews, and that's just to keep the best streaming experience possible for you guys during this hearing. We don't want you guys losing connection or dropping out or anything. So, and also keep your phone muted, keep everything on your laptop or computer muted, because when you're talking and something goes off, if there's a notification, everyone's going to be able to hear it, and it's a public hearing. So, you know, we just want to keep everything as clean as possible without as many disruptions as possible. Next thing will be try to just have WebEx up on your computer. If you have notes on your Windows documents or whatever, anything like that, that's fine. But try not to be on anything that's connected to the internet or something that'll give you notifications, because same as the phone, it'll come right through. The next thing is during recess, just keep your mics muted. During recess, we're still going to be streaming to the public, so anything that is heard during the WebEx call will be heard by everybody. Just mute yourself during the recess. You can turn off your camera as well during recess as well. And if you have any questions for judiciary, don't put it in the WebEx chat. Just talk to your point of contact with judiciary through text or email, and they'll be able to help you out. The next thing is the timer. You should see it up at the bottom. It's a black screen with the 5-minute mark. That'll be your timer from when you guys are giving your statements. You have 5 minutes each time, so try to pay attention to that. You can actually pin it, and this is suggested that you do it. If you hover over the screen with the 5-minute mark timer, you should see in the top right, it has 3 dots. It says more options, and you should be able to click that. It might be locked already, actually, but if it's not locked for you guys, you're gonna wanna lock it in place so it'll always be in front of you so you can see it. And if you just click the little lock button, it should say again timer, and just click timer on that, and it'll lock it. Also, just to keep you guys in the loop, at 2 p.m., the members are going to have a meeting before the hearing, and we ask that you guys have your cameras off and your mics off as well during the meeting. And we'll let you know when the hearing starts, and you can turn your cameras on.
Troy, I have a quick question. This is Maria Elena. I sent a chat to Anthony, I believe, about renaming. Right now, it's only my last name that shows up. I wasn't able to figure out how to rename it myself.
Did you try right-clicking your name on the side on the right where it's under the participant list?
Mm-hmm. The only option it gives me is mute.
Okay, you'll probably have to go into the WebEx app and go to either settings or profile or something of that nature, and it should be able to point you to that.
It's not something you guys set up.
No, I think you should be able to control it yourself.
Okay. Hey, Jennifer.
Good morning.
Okay, Professor Hunt, I'll go through training with you in a second, one more time. Okay, so first things first is background and lighting. It looks like you're good with that. So I'll move on to the mute and unmute check. You should see the mute button in the bottom left, and you should mute yourself at all times if you're not speaking.
Right.
Do you see that? Okay, looks good. Next thing is the camera on and off check. The start and stop video button will be right next to the mute button, and we're going to ask you to have your camera on at all times during the hearing. And if something happens and you need to leave or anything like that for an emergency, we're talking, you know, a kid broke their leg or something like that, as opposed to, you know, the mailman is dropping something off for you. Then just shoot a text or email to judiciary, and we should be able to ask for a recess. And yeah, we're gonna want to keep the camera on just to keep consistency with, you know, as if this were an actual hearing in person. And next is bandwidth. So you're gonna want to make sure that all people in your house are turning off their streaming options. We're talking Netflix, video games, Zoom. Make sure that you're the only one streaming right now, just to keep the experience as good as possible. Causing connection problems and anything like that. The next thing is we ask to mute your phone, turn off all notifications on your computer just to minimize distractions, and try to just have WebEx up on your computer. If you have like a notes or Windows or, you know, Word document or anything like that, that's fine. But just anything connected to the internet, try not to have up on your computer while you're in the hearing. And next up is if we have a recess, just stay muted and you can turn your camera off during the recess, just because we're still going to be visible to the public during the recess. So you just want to make sure everything is muted and not visible during.
Sure thing.
In 1 second, let me handle something real quick. Okay, next thing is if you have any questions for judiciary, don't put it in the WebEx chat. Just send a text or email to your judiciary point of contact, and they should be able to help you out with that. And next is you should be able to see the timer button at the bottom, the timer screen. It's like a 5 minute. Yeah, if it's not locked already, you should hover your mouse over the screen, and you should see a little three dot button right there. If you click that and click lock in place in this position, it should give you another like pull out, and you should click timer on that, and that should lock it if it's not already locked.
Okay, perfect.
Just because, yeah. That's the timer that you're going to be using as a point of reference when you're giving your statement, because each witness has 5 minutes while they're talking.
Done.
Good.
And lastly, you're going to want to, we're going to have the members are going to have a meeting before the hearing. And during the meeting, we just ask if you can mute yourself and turn off your camera until the hearing begins.
Right.
Hi, everyone. I'm going to be doing a mic check for our members. Chairman Nadler, can we do a mic check and video check for you?
Yes. You hear me?
I can hear you. Yes. And I saw your video earlier, so I think you're fine.
Okay.
Thank you. And Ms. Garcia, can we do a mic check and video check for you?
Hi, I'm doing a mic check for Congresswoman Sylvia Garcia.
Perfect. We can hear you. Thank you so
Great.
much.
Thank you.
Hi, Mr. Biggs. Can we do a mic check?
Yep, how's that?
Perfect. Thank you.
You bet.